So when we talk about title, okay, we're talking about equity versus law, okay? A court of equity is one that which can apply equitable remedies to disputes. Now, these courts operate within the legal system, but rather than focusing on the application of law, they look at cases and determine the outcomes based on fairness. In other words, we're all going to hold hands and sing Kumbaya. However, we do have a second court system in which a party can bring an action. Specifically, a court of law must follow the black letter rules, while a court of equity has the ability to do what it deems is fair and equal. So we need to go on the offense instead of going to a court of equity and getting beat up by the courts, by them determining upon themselves as to what is fair and equitable in this instance, which has been determined by other cases pertaining to foreclosure. Because what happens is that the courtrooms opine their decision based on the arguments and the facts that are brought into the courtroom. A good example would be in the state of Nevada. There's a case called Mers versus Edelson, which went all the way to the Supreme Court of the state of Nevada. And there it was ruled that Mers has the authority to do any assignments whenever they please. A year later, 10 years later, they can do whatever they want. And I know many people are saying, oh my goodness, what happened? Because now if you're in the state of Nevada, you have to overcome this burden of a court of equity where they said, oh, MERS can do basically whatever they want. Well, the reason the court opined that decision was the manner in which the attorneys, all right, Jacob Hafner, all right, was the attorney in there, the lead attorney, and he brought inadequate arguments. So if you bring an inadequate argument or an incomplete argument, the judge makes their decision based on what you bring to them. This is why I believe that if you're going to go, all right, you need to throw everything, including the kitchen sink. Because pursuant to res judicata, if you don't bring it forward and you lose in district court, you cannot take it to the appellate level and bring forth new evidence. They're going to ask you, why wasn't this brought forth in your lower court case? So we need to go into a court of law, all right, as the matter that we're bringing them is about law. It's not about equity. So if I'm the plaintiff and I'm saying to the court, Your Honor, the defendants are attempting to exercise a right upon plaintiff's property without lawful authority to do so. Now, although mortgage servicers are able to foreclose under Texas Property Code, that ability, if you're in the state of Texas, I'm talking about me, that ability derives from a principal agency relationship with the owner of that indebtedness and that of a perfected right to the property. A perfected right to the property. So we need to be clear that when we're talking about this, all right, that we're talking about, law. We're not talking about equity. We don't want to talk about equity. Okay. So let's take a look at, because I brought up declaratory judgment. All right. So what does that mean? Okay. So a declaratory judgment is a legal determination of a court as to the legal position of litigants in cases where there is doubt as to their position in law. So it is a form of legally binding preventative adjudication by which a party involved in an actual or possible legal matter can ask a court to conclusively rule and affirm the rights, duties, or obligations of one or more parties in a civil dispute. Now, it is subject to any appeal. Now, although generally a statutory rather than equitable remedy, all right, in the United States, declaratory relief, all right, is historically related to and it behaves in legal terms similarly to other equitable reliefs and declarations, such as those for quiet title. Now, a declaratory judgment by itself, all right, order any action by any party or implies damages or an injunction, although it may be part of a broader ruling of which does, all right, do the injunction. So the declaratory judgment does not resolve an actual case or controversy, but what they do is they provide legal certainty as to each party in the matter which could resolve or assist in the agreement. For example, one of my biggest things that I talk about is determining the status quo of the parties before you invite them to your party. An example would be many times I see hundreds of quiet title complaints that have been filed, and then they name everybody and their mother to this quiet title party, and then they want to kick them out. So before inviting everyone to your quiet title party, I say let's do a status quo of the parties through a declaratory judgment and come to a determination as to what is their status. Do they have they acquired any rights in accordance with law to come to your party? Because if you can show that they have not acquired rights in accordance with law, all right, then you get that order and then it's filed into public record, and now we've got preclusion. All right, we've got res judicata where they cannot come back in the future because a court has determined that they had not acquired rights in accordance with law. So declaratory judgments are authorized by statute in most common law jurisdictions. But again, it's very powerful, and this is something that I look at, again, thinking outside of the box. Now, foreclosure is all about rights acquired. Now, they won't tell you that because foreclosure, all right, is an alternate means of collection. They could either collect on the note or they can collect through foreclosure, through the foreclosure through your security instrument, meaning that you have a due on sale clause if you have a deed of trust or if you have a mortgage. You have a clause that says that they can sell your property. The problem is that that security instrument needs to be properly secured to the debt, which is evidenced by the tangible promissory note. All right? That doesn't always happen. All right? Now, in today's world of securitized mortgages, all right, a secured home mortgage loan consists of two tangible parts. All right, the tangible promissory note, all right, and a contractual lien instrument being either a mortgage or a deed of trust, or if you're in the state of Georgia, it'd be a security deed. All right, now, in reviewing your security instrument, all right, one must evaluate the negotiation of that instrument, all right, and then consider what laws are applicable, all right, to that security instrument upon negotiating the tangible promissory note. That's what I do. All right, I look at all of the laws that are applicable. What was supposed to happen? What did happen? What did not happen? Okay? All right. I identify the parties entitled to enforce using statutory requirements of law on mortgage loan instruments. Now, one of the things that comes up many, many times, all right, is who is the person entitled to enforce a note and to whom the obligation is to pay the note owed, meaning just because you're entitled to enforce the note, right, that doesn't mean that you are the owner of the note or the owner of the debt. All right, so I need to identify who Pete is. All right, now what we can do, and I'm going to use Florida for this. Let's look at Florida. Who is Pete? Now, many times, opposing counsel comes and they say, I'm Pete. I'm person entitled to enforce the instrument. I have it right here. They don't claim to be owner. All they say is, I'm the holder. I'm acting on behalf of whoever, John Doe, Mickey Mouse, Donald Duck. Now, under here it says, under FSA 673-3011, person entitled to enforce instrument. The term person entitled to enforce an instrument means, one, the holder of the instrument. Okay. Two, a non-holder in the possession of the instrument who has rights of a holder, or three, a person not in possession of the instrument who is entitled to enforce the instrument pursuant to 673-3091 or 673-302. So let's see. All right. Now, a person may be entitled to enforce the instrument even though the person is not the owner of the instrument or is in wrongful possession of the instrument. And this is where they say even a thief may come in the night and steal your property. If you were to go driving with your friend down the highway, and as you're driving, you see a brand new Mercedes 500 SL parked on the side of the road, the engine running. And your buddy gets out and says, hey, somebody left me our car. And your buddy gets in and he's driving. He takes the car. Keys in it. He's driving. He's got it. He's in possession. Right? Now, he decides he wants to sell it. He's got a new car. He wants to sell it. And you know what? I'll bet you he can find buyers for this. But is he the owner of it? No. Has he acquired rights? No. Is his name on title? No. Oh, but wait a minute. I've got the keys. I'm driving it. So when you look many times as someone claiming to be Pete, I am the holder. All right, we need to take a little better look as to, okay, what does a holder mean? Does that mean that the mailman can be a holder? Or if you're in Colorado and you're at a Rule 120 hearing, and they say, you know what, I've got the note. This is it, I'm the holder. I can do whatever I want, I'm the holder. Let's look at, I'm going to use Florida because I just happen to have a lot of their stuff here with me. This is in Florida statutes under general definitions, Uniform Commercial Code. It says, one, let's talk about holder first, then we'll talk about bearer. Holder means A, the person in possession of a negotiable instrument that is payable to bearer or to an identified person in possession, payable to bearer or to an identified person in possession. B, the person in possession of the negotiable tangible document of title if the goods are deliverable either to bearer or to the order of the person in possession or C, the person in control of a negotiable electronic document of title. Now, we're not talking about electronic, so C automatically doesn't come into play. But when we look at A, it says payable to either bearer or to an identified party. All right. Now, when we're up on top, when we look at here, number 5, under definitions, the bearer means a person in control of a negotiable electronic document of title. Well, that doesn't apply. We're not talking about that. Or a person in possession of a negotiable instrument, a negotiable tangible document of title, or a certificate of security that is payable to bearer or endorsed in blank. Okay, but it says bearer. Right, now, we can go to Florida's 3205. All right, they just talked about the endorsement in blank. So it says special endorsement in blank. If the endorsement is made by the holder of the instrument, whether payable to an identified person or payable to bearer, the endorsement identifies a person to whom it made it payable. All right, so that's what they're saying. The endorsement identifies a person. When specially endorsed, the instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person. Okay. 2, if an endorsement is made and is not a special endorsement, it is called a blank endorsement. When endorsed in blank, an instrument becomes to bearer and may be negotiated by transfer of possession alone until specially endorsed. Again, all they are doing, all right, is claiming to be the holder of a blank endorsement document. All right, now, if we look at incomplete instrument, under Florida Statute 673-1151, it says, 1, the term incomplete instrument means a signed writing, whether or not the contents show at the time of signing that it is complete, but that the signer intended it to be complete by the addition of words or numbers. Okay, so pay to the order of, all right, states intent. All right, you are going to name a party. How many times have you gone to a bank? And I go to the bank and my wife says, Joe, I need you to go cash check. We need some cash. Got to go pay some bills. Here's a check. And I run down to the bank. And I take the check and I just hand it to the teller. And the teller I've known for 10 years. Teller hands me the check back. She says, Mr. Esquivel, you didn't fill in the check. You didn't put a name. Well, what does that mean? She says, there's no named payee. It states pay to the order of, but there's no name. I can't cash this check unless you write cash or unless you put somebody's name in there. Okay, fine. I'm going to write my name in there, hand it back to her, and she hands it back to me. She says, Mr. Esquivel, you forgot to sign it. Well, can't you cash without me signing it? No. There needs to be a signature. All right, so now there's to be an identified party, and there needs to be a signature. All right? Now I sign it, hand it back to her. Okay, I need to see some ID. Oh, shoot, wait a minute. I forgot my wallet. Oh, come on, Tanya. I've been here 10 years. You know me. I'm sorry, Mr. Esquivel. I need to see some sort of an identification. The same for a check, the same for an endorsement. When we look at the statute, oops, sorry, wrong way. Florida Statute 673-1101, identification of person to whom instrument is payable. 1. The person to whom an instrument is initially payable is determined by the intent, whether or not authorized, signing as or in the name or behalf of the issuer of the instrument. The instrument is payable to the person intended by the signer, even if that person is identified in the instrument by a name or other identification is not that of the intended person. Okay, so it's payable by the person intended. So when they say paid to the order of, there's a reason that they wrote that. We're going to go through a few minutes and we're going to go through a bearer and order paper, a quick little PowerPoint presentation. Again, we need to understand what was their intent. Everyone claims that it's bearer paper and that they know what bearer paper is. But the reality is they don't. They have no idea as to what is bearer paper, what is order paper. Everyone thinks that they're talking about the same thing. However, what one person is looking at, what another person is looking at, are two different things. Okay, this is bearer paper. All right, you see up on top it says, will pay to bearer at the county treasurer. That's bearer paper. Here's mine. I just created this. The all-new bearer instrument, payable to bearer on demand. Here's two more. All right, payable to bearer on demand as authorized by law. Here's another one. Will pay to the bearer on demand. In all the thousands of documents that I have reviewed in the past 4.5 years, 5 years, I have never seen the word bearer on any of these documents. Okay? This one goes back to 1860. Will pay the bearer at the office of the treasurer. These are bearer instruments. No one has disputed that. But a blank line with an as of yet unnamed payee is something that they are leading you to believe, because when they say to you, Johnny, can you fill in the blank line? Johnny, here's an application, fill in the blank spots. So they're getting you to understand that something was to be put in that blank line. All right? But to claim to be the bearer, no, you're not the bearer. You're just a person holding that piece of paper. This is order paper. Paid to the order of. All right? I'm giving specific instructions. Pay to the order. Payable to bearer. It's not hard to see the difference. It is not. Every one of those stamps that you have seen, pay to the order of. Oh, I'm sorry, the party has not been identified yet, but yet on some of these notes that we look at, you see 2 or 3 different endorsements where a name has been filled in. Okay, so why don't you fill in the name? In order to have an agent-principal relationship, all right, parties need to be identified. In this case, they haven't been. Okay. A blank endorsement would be John Doe. Special endorsement, paid to the order of, then signature. And a restrictive endorsement would be for deposit only. Again, it's very simple. A blank endorsement consists of a signature alone. All right, if you take a check and you sign the back of it, all right, that's a blank endorsement. All right, that's all it is. Special endorsement, all right, you're given specific instructions, pay to the order of. And then restrictive endorsement, for deposit only. But yet they would have you believe otherwise. So these are just a few examples. So let's continue. Give me a moment. All right, 1 minute. So let's continue. So we are at, all right, again, so we're talking about acquiring rights. We've gone over the Pete, we've gone over the holder. Let's look now, let's jump to acquiring rights. 1 second. 303. Okay. Yeah. These are basic rights. One moment, I need to pull up 3203 for a second. Here we go. Again, they have not acquired rights in accordance with law, like they would have you believe. All right, this is Florida 673-32031. Transfer of rights. Rights acquired by transfer. Again, remember, that is the whole point of what we're talking about, rights. 1. An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the right to enforce the instrument. Okay, now 1 just identified what is to be done. Now 2, 3, and 4 are going to place restrictions on how it is to be done and what can be done. All right, so let's jump down to 2. Transfer of an instrument, whether or not the transfer is a negotiation, vests in the transferee any right of the transferor to enforce the instrument, including any right as a holder in due course, but the transferee cannot acquire rights of a holder in due course by a transfer directly or indirectly from a holder in due course if the transferee has engaged in fraud or illegality affecting the instrument. So what they're saying is if there was anything illegal or fraudulent that has happened and affected the instrument, then negotiation cannot take place. So was there any fraud or illegality affecting any of these instruments? I'll let you make that decision. Let's look at number 3. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement by the transferor, the transferee has a specifically enforceable right to the unqualified endorsement of the transferor, but negotiation of the instrument does not occur until endorsement is made. So it says negotiation of the instrument does not occur until endorsement is made. So if there is no endorsement, negotiation does not take place. Lack of endorsement. All right. So let's go next. Number 4. If the transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this chapter and has only the rights of a partial assignee. So what we have to understand is, what is the entire instrument? Okay, well, the entire instrument is the tangible promissory note, the intangible obligation, which is your promise to pay. All right, I promise to pay $1,500 for the next 360 months. All right, that is the intangible. And then we're talking about the security instrument, all right, which is properly secured to the debt, which is evidenced by the tangible promissory note. So in tandem, you must own all at the same time, and it must be timely. All right? When one acquires Part A, one at the same time must acquire Part B and Part C. So when a sale of the tangible promissory note is made, all right, from Mickey Mouse to Donald Duck, right? Mickey Mouse at the same time would do an assignment of mortgage, right, to Goofy or Donald Duck, whoever they were selling the note to, right? Thus, they would have released any interest that they would have had in the security instrument, and they would have signed it from Mickey Mouse to Donald Duck or to Goofy, and then they would have taken that assignment and they would have filed it into public record, all right? And then public record, it would have been filed, indexed, all right, and recorded, all right? Now we've given constructive notice to the world, all right, that a sale has taken place and that there is a new properly secured party, all right, and now the mortgage follows a properly secured note, all right? Now, the note was sold, the debt was sold, an assignment was made of the security instrument. So all at the same time this happens in a perfect world. That is not what happens in the real world today. Many times we have many parties out there that buy partial interest of loans. For example, we have Fannie Mae, Freddie Mac, Ginnie Mae. These entities are called government-sponsored entities, and they buy an interest of your mortgage loan. All right? They don't go out and physically go buy the note. That's not what they do. All right? So when you understand that, they're buying a partial interest of the note. Right? We have many, many times heard Fannie Mae owns your loan. Well, really? Are they named to the note? No. Are they named to public record? No. No, but yet they claim that they've acquired rights. So when we talk about Pete, again, everything goes back. It goes about rights. It goes about title. It goes about perfection of security interest, right, pursuant to local laws of jurisdiction. All right? So when we're talking about perfection, how do you perfect something? You file it into public record. Why? Because that is what is the accepted practice. All right? In this, all of these states out there, they all have statutes saying that you must record the instrument for a deed of title or a mortgage. Now, they don't all have statutes pertaining to assignments, all right, and that's fine. However, just because there is not a statute that says that you must assign does not mean that you don't have to assign. I'll give you an example. You and me are riding down the highway, and we're on motorcycles, and we're in a state that doesn't require helmets. All right? Now, I have a helmet on. I have a full set of leathers, gloves, boots, chaps, the whole 9 yards. I'm covered head to foot. You're wearing a pair of gym shorts, tennis shoes, and a Dago tee, enjoying the sun. And we're going down the highway 90 miles an hour, just enjoying life, and suddenly a car pulls out in front of us. We both hit the car. What happens? Okay, well, I have a few bumps and scrapes. You didn't have a helmet on or any protective gear, and you're dead. But that's okay because you didn't need to wear a helmet, all right, when you went flying and your head hit the wall. Now, the same thing applies to a security instrument. Not all states have assignment statutes, and that's okay. Just because they do not have them on the books, all right, does not take away from anything of them acquiring a properly secured security instrument done in accordance with law. Because failure to record has consequences. Remember, failure to do the recording has its consequences. So let's proceed. Give me 1 second. All right. Let's just do this. Okay, we're going to talk about, to give you an idea of what I look at when we are talking about these documents. When we're talking about assignments of deeds of trust, here's an assignment of deed of trust. Now, what this states and the purpose of an assignment, whether this is an assignment of deed of trust, an assignment of mortgage, an assignment of a security deed, you need to understand the whole purpose of an assignment is to memorialize a transaction pertaining to the tangible promissory note and the acquiring of rights. The assignment does not cause that. All right? The sale and the acquiring of rights is done through statutory requirements of law. But it is a misnomer that the banks bring to the courts saying, well, I have an assignment. What was assigned? The mortgage or deed of trust, that's just the collateral. That's personal property. That's not real property. So if you have assigned a deed of trust, their assignment, they're attempting to memorialize that a transaction took place. All right, so let's go through one. Let's look at the assignee. Let's look at the assignor. Let's look at the property description, because these are not true and correct many, many times. They have the wrong property address, the wrong MERS, min identification number. So every one of these boxes is what I look at when I'm looking at an assignment. And here it says, all beneficial interests and rights accrued or to accrue. Okay. You look at, what was the date that it was assigned? Because who signs it? Here we have MERS assigning as nominee. Many times you'll see 3 or 4 assignments from MERS in one property. And they don't realize once you've assigned it away once, oh, how do you go back and then get it again? How do you go back and get it a second time, a third time? And each time you're naming the same original lender. Oh, I'm acting for the lender and all successors. I'm acting for the lender. Well, wait a minute. You've already assigned this once or twice or 3 times, or I just had one which I had 5 assignments on a property. So these are all of the things that need to be looked at. The notary date, where was it notarized at? Who notarized it? Many times you have parties sign them, you have the attorneys in the office of the lawyer's firm that is representing the owner, supposedly. The lawyers are signing this. They're signing this as attorney in fact. For who? Doesn't say, just as attorney in fact. I looked up one this week. I had a woman that her name was on the endorsement as attorney in fact. Her name was on the assignment as attorney in fact. And I went and did a background search and found out that she was working for she's a partner in the law firm that worked for the servicing company in foreclosing on this entity. So things are not what they tend to believe. All right. Now, another thing, I'm just going to touch on it briefly, but when the assignment is made into public record, all right, it is the act, all right, of filing that into public record, all right, which causes a color of title claim to your property. All right, when Party A files an assignment into public record, all right, it is that claim to your property now, which is a color of title claim that many times homeowners and attorneys forget. That is what is doing damage. That is what is doing damage. The act of recording that assignment. All right? When you file a quiet title action, all right, and there is an assignment or two assignments or three assignments on your property, those are parties with equitable colors of title claim to your property. And this is why many times in California or Arizona or in some of these non-judicial states, they take your quiet title action, they move it to federal court, base it on diversity and the monetary threshold limit, and then opposing counsel files a motion to dismiss, and you're issued a 12b-6. Failure to state a cause for which relief can be given. Why? Well, you've got other parties that have got claim to your property. There's still claims out there. You have not paid or discharged or satisfied the debt. So it's not proper for you to come forth with this quiet title action. All right, so again, you need to understand these documents are not always what they purport to be. Even though it says it's a true copy, who made the copy? When you're looking at the endorsements, these are things that I look at. You know, who is getting paid what? Who is endorsing it? What is their title? The notice of default, okay? What is a notice of default? Someone is making a claim. Notice of default is someone has said, you owe this much money. You need to dispute it. When you have a notice of default, all right, it says here, you owe this much money. If you don't agree to pay this, right, you need to dispute it. Again, your situation may be a little different, but they're all very similar. All right, so I'm not making any of these up. What you have to understand is that your state has a specific requirement for what was to take place for securitization. All securitization is the pooling of a bunch of loans that are pulled together and then they're sold, all right, to an entity. Now, I'm just giving you a generalization. There's a list of steps that must take place, all right? All right, there's a set of rules that must take place because many of these entities that are set up under called REMICs, real estate investment mortgage conduits, all right, or you hear the phrase RMBS, residential mortgage-backed security, right? They all have rules that they have to follow, right? And again, many of these rules came up. Right now we're using UCC, or we're using your state's codified version of Uniform Commercial Code. And before the Uniform Commercial Code, we actually had the Negotiable Instruments Act of 1881. All right, so these are statutes that we look at as to what needs to be done. All right, the Securities Act of 1933 and the Security Exchange Act of 1934 play a very important and significant part in what was to be done, what was not done, all right? Because after we had the recession, all right, from 1929 to 1931, right, President Roosevelt said, hey, we can't do this. All the people got screwed. They lost all their money. And this is why you have what's called the 424B5 rule, in which all investors now must be given a prospectus, right? And that prospectus tells the investor what must be done. And the governing documents, which are a pooling and servicing agreement, specifically lay out a specific set of guidelines as to how it is to be done, the parties that are to be into it, all right? And then in addition to that, they must file with the IRS. And most people don't understand but the IRS gives them certain privileges, all right, when they decide to be a REMIC. Because a REMIC is a real estate mortgage investment account, it means that the taxes pass from one entity to another entity to another entity through another entity, all without party A, B, or C paying taxes. Party D is the party that pays the taxes. Now, the reason for these different transactions is that they need these special purpose vehicles to be bankruptcy remote, meaning there needs to be at least a minimum of 2 arm's length transactions, party A to party B to party C. That is what is stated within the pool and servicing agreements. That is what is stated within the trust agreements. However, that does not always take place. And we're not holding our feet to the fire. They're saying we're not a party to it. But one of the things that they do is they file with the IRS. All right? And it's called IRS Publication 938. And you can go to the IRS website and you can pull the publication. They're done quarterly, and depending on the number of trusts that were created for that quarter, it can have anywhere from 15 pages up to 100 pages. But every trust that is listed within IRS CUSIP number is identified in those publications. So whether you are Fannie Mae, Freddie Mac, whomever. So the name of the trust is listed. The CUSIP number for the trust is listed. All right. And then all of the classes are listed. How many classes is this one going to have? All right. And then the CUSIP numbers for the trust. They're all here as well. Now, these different classes, all right, represent different investments for different parties, meaning that they can have one trust and they can have 3 or 4 different types of investors. Now, it's very important to understand this because they say, what are all these classes? What are all these tranches? Tranche is another word for class. So you have class FA, FH, GA, GY. Again, however they set them up. But you have senior classes up on top, all right, followed by junior classes at the bottom, and then mezzanine classes, junk classes at the very bottom. Okay, the senior classes, all right, are collateralized by the junior classes. And it's very important because there's been a large misinterpretation. In a senior class, I'll give you an example. You have an investor, all right, that is very reserved and, say, an older party, and they want to risk very little. They want a set determination every month of residual income coming in. Okay, so they're going to receive less money, but it's guaranteed. Every month you will get, 0.75, percent of principal and interest received. All right. Again, whatever the amount is, it's listed in the underwriting agreement of the 424B5 prospectus. Now, someone wanting more return on their money, all right, would go to a different group. All right. All right. And in that group, all right, because within these classes, within these different trusts, you have different groups, 1, 2, 3, you can have 7, 10, whatever. Group 1 has classes A, B, C. Group 2 would have classes D, E, F. And Group 3 would be G, H, I. So Group 1 would be senior, all right, and they pay out a set amount, all right, and there is very little risk for loss. Group 2 pays out a little more with their classes, all right, but there is a bit of loss, there's a bit of risk, all right. Now, Group 3, you have the Mavericks, young guys, 30 years old. I can wait 30 years for my money. I want more money. I want more bang for the buck. All right? So those are your Group 3. And again, you can have 4 or 5 different classes within one group. All right? So while the earnings are paid from the top down, the payoffs are paid from the bottom up. You can have a specific class or tranche that has only a shelf life of 1 or 2 or 5 years, or based on the amount of money paid out, then it expires, all right? And that is determined within the underwriting standards of the 424B5 prospectus and the pool and servicing agreement. So the misnomer that many auditors have given you, where they would say, oh my God, Joe, your loan is paid off. Look at that. You're in 6 different classes. You're in group 7. And of those 6 classes, 3 of them are paid off. Oh my God, you don't owe any money. 3 of your groups are paid off. Can you believe that? Well, that's a misnomer because a tranche was paid. All right? However, there was still an interest of that loan, all right? That loan payment still going to the trust. So your loan wasn't paid off, right? Those investors for that particular tranche or class were paid. So just to give you an idea, again, what the IRS Publication 938 is, in order for one to acquire the right to be a residential mortgage-backed security and to be called a RMIC, all right, and to be in compliance with it's under USC 26 USC 860D, all right, 26 is IRS. So in order to be compliant with them, all of the assets need to be into the trust by this closing date, the startup date. For this one, it's 7609, all right. On this particular one down here, it's 6/30/09. So whatever date is listed, all right, by this date, all of the assets must be in that trust. Now, they didn't say note, all right, is what they're going to claim. If you read the pool and servicing agreement, it says all interest, I-N-T-E-R-E-S-T. Well, it could have been the beneficial interest. What was the beneficial interest? Oh, that intangible payment obligation. Well, if they just took the intangible payment obligation, all right, I understand that. So that means that they only took a partial interest. But yet, again, IRS says, well, all the assets must be in here. But yet we see assignments left and right every single day. Hundreds of thousands of assignments are filed. You know, this is January 20th, and we're doing an assignment of mortgage filed into a 2006 trust. Wait a minute. The startup date said down here, 2006, or this one, 2009, but yet we're doing an assignment of mortgage. So either you've lied to IRS or you're lying to public record. So the question becomes, whom are you lying to? All right? So we need to understand what exactly it is that we're talking about. Who's lying to who? So one of the things I'd like to do next is let's go to verbiage definitions. And this is very important. And the reason that this is important to me is because so many times I talk to many people, I talk to many different groups, I talk to members of different associations, and I hear many different words given, I hear many different definitions. Now, what the homeowner is talking about, for instance, when he's talking about his loan, and when the attorney is in court and they're talking about the loan, and the judge is talking about the loan, everybody has a different perspective as to what they're talking about. Are we talking about the note? Are we talking about the security instrument? Are we talking about, what is it we're talking about? So we need to be very specific. And if anyone has worked with me, they'll know that when I'm talking, I ask, are we talking about the tangible promissory note? Are we talking about the electronic note? Are we talking about the intangible obligation? You know, what is it that we're talking about? Because you must specifically define with particularity and specificity as to what it is you're talking about. You may mean one thing, but the words that come out of your mouth say something else, and the words that are on paper are a completely different thing. So this is my definitions. Okay, the definitions here are not substitutes for legal definitions provided by appropriate legal counsel. These definitions are to offer a general understanding of terms. Again, I need to have you understand what it is that I'm talking about. So when you decide to talk about whatever it is you're going to talk about, we are on the same page. Okay. A mortgage loan. A mortgage loan is a loan secured by real property through the use of a tangible promissory note, which evidences the debt and the encumbrance of property rights through the granting of a mortgage or deed of trust, which secures the loan. However, the word mortgage alone in everyday usage is most often used to mean mortgage loan. So, not to confuse you, but many people use the word mortgage, and if, yeah, I talked to my attorney about my mortgage. Well, are we talking about the security instrument, or are we talking about the mortgage loan? Again, we need to be very specific as to what it is, the ideas and that we are conveying to the person that we are speaking to or writing to. Tangible promissory note. The tangible promissory note is a piece of paper that can be touched that contains the promise to pay. But the real significance is not the physical paper, but the legal rights which the paper confers. And hence, the promissory note is defined by the legal debt. The note is a tangible negotiating instrument that evidences the intangible obligation, which is your promise to pay. I, Joe West, will promise to pay. Okay, so that note evidences that promise. That's why it's so important. This is why we have what's called statute of frauds. Why? Because mothers will kill their daughters and fathers will kill their sons over land. Everything must be in writing. In order to have a mortgage loan sale, right, it must be in writing. It must be tangible. You must be able to touch it. This is why you have a collateral file. All of your papers go into this collateral file, right, which can hold anywhere from 200 to 300 pieces of paper in there. Okay, security instrument is the mortgage or deed of trust, or if you're in the state of Georgia, a security deed, is seen as a real property lien if filed of record, and it is a separate contract listing an alternative means for collecting payment due under the intangible obligation, evidenced by the tangible promissory note. So, your mortgage or deed of trust document, all right, is seen as a real property lien if filed of record. All right, and it is an alternate means of collection. Remember, they can collect on the note or they can collect through foreclosure. Very, very, very seldom have I have never seen anyone come forth to collect on the note, saying, "No, I have the note, it's endorsed to me, you owe me, I'm getting a judgment for you." No, they're going through foreclosure, which is an alternate means of collection. Okay. The entire instrument. Okay, the entire instrument is comprised of both documents, the tangible promissory note and the tangible security instrument, which would be either a mortgage or deed of trust or a security deed if you're in the state of Georgia, along with the intangible obligation. For there to be a right to enforce any part of the entire instrument, all three parts, tangible and intangible, must be named to the same party. In the case of the tangible security instrument, named in public record, and in the case of the tangible promissory note, on the document itself being either to the lender or endorsed to a specific party, and in the case of the intangible obligation, in the transferable record. The same party must be named to all three, and it must be timely as well. The tangible obligor, you hear that many times, and you're wondering, scratching your head, who is the tangible obligor? That's the party that signed the tangible promissory note. The tangible obligee is the party whom is named on the tangible promissory note either as lender or is properly named as a payee on the payee line, physically affixed to the tangible promissory note. So the lender would be the tangible obligee. And I use the word tangible because it's evidenced by that piece of paper. You can touch it, you can feel it. The intangible obligor. All right, intangible means you can't touch them. It's intangible. This is a party that creates the intangible obligation using the intangible payment stream of the tangible promissory note. Okay, now I know that sounds like a lot. So let's break it apart a little bit. All right, we have a note and we have a promise to pay within the note. I promise to pay. Your promise, all right, when you state I promise to pay for the next 360 months, all right, that is a right to collect future payment obligations for the next, whatever, 30, 40 years, whatever you sign for. So whoever owns your promise, all right, that is the intangible obligation. The right to receive future monetary from the party. Future obligations. You're obligated. So the party that creates the obligation using that payment stream, right, because many times they sell it, right? The intangible obligee is the party that purchases the intangible obligation from the intangible obligor. They're seldom filed of record as a secured party to the tangible obligor security instrument. For example, I'm with Countrywide. They're my lender. And Countrywide sells an interest to Fannie Mae. Okay. Well, what Countrywide sold to Fannie Mae was an intangible obligation that was created off of my payment stream that is evidenced by my tangible promissory note. I didn't agree to pay Fannie Mae. Countrywide said, hey, I've got something I'm going to sell to you. Okay. Now, they're called the account debtor. Now, account debtor means a person obligated on an account. Okay. Chattel paper, general, intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. So, we have Countrywide. In Countrywide, they own the note. I signed it with them. I agreed to pay them for 360 months, X number of dollars. All right? Countrywide says, hey, I'm going to sell it. Now, to give you an idea, let's suppose, all right, that let's take Chandra. Chandra owns a strip shopping mall, and Chandra's in Maryland. And Chandra's gotten behind in some bills. However, one night he wakes from a dead sleep and he's had an epiphany. Wait a minute. I've got some leases. I own a strip mall, all right, and that strip mall has 10 stores in it. All right, and I'm renting out 9 of them stores. You know what? I've got leases for the next 10 years. Those leases are worth $500,000. I can sell that. And Chandra does. And that's legal. All right? So even though he owns a strip shopping mall, he has sold the leases the right to collect future payments. All right, so now jump back to my situation. Countrywide owns the note. Countrywide says, hey, I've got all this payment coming in. You know what? I'm going to sell these payments to Fannie Mae. Fannie Mae, you want to buy some payments? Fannie Mae says, yeah. Fannie Mae buys the right to collect future payments. Okay. Now let's just take this a little step further. There was a case in California a number of years ago, and it's called Kemp, K-E-M-P, versus Countrywide. Now, during that trial, a particular person, there are a number of people who were deposed. One of them was a woman by the name of Linda DiMartini. And it is within her deposition, I believe it's on page 14, in which she states, Countrywide is not in the business of selling notes. Countrywide is in the business of selling beneficial interest. Wow, imagine that. But yet it would make perfect sense because Fannie Mae is not named to the note. Fannie Mae is not named a public record. But yet, wait a minute. Oh, I've checked their website. It says Fannie Mae owns my loan. I'm confused. And this happens all day long. On the courthouse steps, they go to sell a property. They say Federal National Housing Mortgage Association say secured credit is a qualified bidder. Wait a minute. How the hell are you a qualified bidder? You know what? I'm an investor. All right. I know the party that owned that house, and they had a copy of the note. I didn't see Fannie Mae named in the note, and I've checked public records, and I didn't see Fannie Mae or, Fannie Mae named a public record. So I'm a little confused because a qualified bidder doesn't have to put up a $75,000 cash amount every time they purchase a house. They said, nope. All Fannie Mae says, yep, I bought it. What did you buy? You claim to own something, and now you're buying it back? Or Bank of America claims, well, you know what? We're buying it back, and we're selling it to Fannie Mae. Well, what did you purchase? What money was used? Who did you pay? Oh, I bought it for myself, paid myself, and sold it to myself. Very few people look at this. So again, sorry to get off track, but again, account debtor means a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. So the homeowner didn't contract with Fannie Mae. The homeowner didn't contract with Freddie Mac. The homeowner didn't contract with Residential Securities LLC, which is a depositor that sold it to some RMBS. There was a third party that sold that intangible obligation. All right. We hear a lot about this company called MERS. What is MERS? Need to understand, MERS is Mortgage Electronic Registration Systems Incorporated. MERS is a wholly owned subsidiary of MERS Corp. Incorporated and serves as a mortgagee in a nominee capacity for the lender and subsequent assignees. People, the truth is that MERS is an electronic database that is used to track the intangible obligation as well as the servicing rights. They do not operate in a tangible world. Again, I repeat, they do not operate in the tangible world. So even though they're stated within the security instrument, that is the only place that they are. They did not loan any money. They do not receive any monies. They're in an administrative capacity, all right, to track the payment, to track the intangible obligation, as well as the servicing rights. Now, as a matter of fact, let's just, give me 1 second. Oops, sorry. Okay, let's jump over here 1 minute. I think I have something I can share with you. Just an example, and then we'll continue. Okay, here is a MERS milestone report. This shows, all right, October 5th of 06, they registered this loan to MERS. Okay, American Mortgage Company LLC, servicer. Okay, Ally Bank, right? They released the funder's interest. Right? They transferred beneficial rights to a new investor. Wells Fargo, home mortgage division of Wells Fargo Bank. All right? They transferred beneficial rights. They transferred servicing rights. Then it went into foreclosure status. This has nothing to do, it doesn't say that they've transferred the note. It doesn't say that they've transferred a mortgage. It doesn't say they're transferring a deed of trust. All they're talking about is servicing rights and the intangible obligation. That's it. What you think MERS is and what MERS actually is, and we'll go into later if we have time, is two different things. So again, all they are is a database. They do not operate in the tangible world, period. And then we're back to title. Okay, so again, I'd like to think about the definitions and, look at what it is that you're talking about. All right? When you understand that when you're talking about your note was sold, well, was the e-note sold? Was it a tangible note that was sold? What was it that was sold? We need to quit giving admissions, because when you admit, all right, you can't take it back. All right, so one other things I would like to do is actually for Florida, and again, we have different statutes for different states. So depending what state you're in is specifically different statute. Now, in Florida, we were talking about assignments. Let's look at Florida statute 817.535. Unlawful filing of false documents or records against real or personal property. Okay. 1. As used in this section, the term A, file means to present an instrument for recording in an official record or to cause the instrument to be presented for recording in an official record. So what we have is a statute, right, that is saying it's against the law if you record a false document. Okay. B, filer means the person who presents the instrument for recording in official record or causes an instrument to be presented for recording in official form. So, if you file something that's a false document or a false record, Florida has a specific statute that says, hey, you're breaking the law. But yet it's done thousands of times every single day. We have 60 counties in Florida. All right? It's done again and again and again. Thousands of times. And it's done to create a bread trail. And they don't realize that. It's a bread trail that they're trying to create. Everything is done electronically. But when you look at electronically, all right, well, wait a minute. I signed a tangible note, and they're talking about electronic filings. Well, we have statutes pursuant to 15 U.S.C. 7003, right, which states that you can't do anything electronically. Okay, this specific statute, all right, which is 15 U.S.C. 7003 states, okay, that the Uniform Commercial Code, Article 3, Article 9, your state equivalent, all right, is not governed by e-sign and UETA. I mean, this is something that every day they file hundreds and thousands of electronic documents. And they're operating outside of law. And we need to bring this forward again and again and again. What you claim to do and what you're doing are completely outside of law. This color of title claim that they're doing to the properties. Let's take a look over there. 1 second. Here we go. Okay, color of title. I talk about this. So, color of title. And this is very important. A person has color of title to a piece of property when for one reason or another the document evidencing title, a deed or a mortgage instrument, for example, is invalid. The appearance of a legally enforceable right of possession or ownership, a written instrument that purports to transfer ownership of property, but due to some defect that does not have that effect. A document purporting to pass title to land, such as a deed, that is defective due to a lack of title in the grantor, passes only color of title to the grantee. It has been held that in order to pass color of title, the instrument appearing to pass title must be in good form, duly executed, and profess to pass good title. So what they're doing is when they file these assignments, they're claiming to have a superior claim to land, to your lien. All right? I am assigning all beneficial interest in a mortgage together with a note and debt and all obligations due. Just because you say it's so does not make it so. If they have not fulfilled all the statutory requirements of law in acquiring rights to the property, rights to the instrument, rights to enforce, then all they have is simple possession, not legal possession with rights. I'll give you an example. Let's talk about, we can go to Bank of America, all right, or Countrywide. Countrywide was bought in a portfolio sale in 2010 by Bank of America. All right. Let's fast forward now to 2014, 2015. We have a homeowner that had Countrywide Home Loans, or Countrywide FSB, and now we've got Bank of America saying, hey, I've got your note. You're like, wait a minute. They said that Fannie Mae owned my note. Nope, I've got your note. How the hell did you get it? I am the owner of your note. Well, when Bank of America purchased Countrywide, you have to ask yourself, what did they purchase? When J.P. Morgan Chase purchased WAMU, what did J.P. Morgan Chase acquire? All right. Well, if we know that Countrywide sold beneficial interest, and if we know that WAMU sold beneficial interest in loans, then we can ascertain, all right, through just common sense, that they kept all the original documentation. They never sold it. All right? They held on to it. It was theirs. It was their personal property. Okay. So in all these millions of boxes, Countrywide has a document that at one time purported to be a promissory note and a deed of trust, and J.P. Morgan Chase has millions of boxes in warehouses, and they at one time were promissory notes that evidenced debt and mortgages that were secured by recording, filing, indexing the public record. But wait a minute. The beneficial interest was stripped and sold. So it's like taking a cow and you cut off the tail and you sell the tail, all right? Now you have less than a whole cow. You sold the tail. Years later, you want to reattach the tail. You can't reattach the tail. You cut it off. So you have Countrywide coming forth, or you have J.P. Morgan Chase coming forth saying, hey, I've got the note. I got the note. I own the note. I'm the holder. Okay. Well, if for Countrywide, they sold the intangible obligation to Fannie Mae, all right, the intangible obligation was the debt, beneficial interest, all right, then that tangible promissory note no longer evidenced that debt. That debt was sold. All right, so it just became a worthless piece of paper. And the selling of that debt, all right, meant that the mortgage was no longer evidenced. Okay, so when we understand that, we need to understand that when J.P. Morgan Chase says, well, I bought all of our assets. Well, wait a minute. Those assets were not what they claimed to be. All right. Those loans, in fact, were liabilities. All right. And those intangible obligations that were sold, or that beneficial interest sold, was a right to receive future payments. Right. That is something that they have not acquired in accordance with law. They have simple possession, not legal possession with rights acquired. Let's go over an infographic. An infographic is available only to mortgage compliance investigators, and we created it, and we're the sole parties and owners of it. We're copyrighted as well. All right, so let's look at a loan that went into an RMBS. All right, what really happened? All right, well, let's start at the top, and we're going to use Florida. Okay, we have the borrower. We have John Doe. Okay, all right, so John Doe signed at closing. Here's the closing date. Now, he had two documents. He had a note and a mortgage. These are both tangible, can be touched and felt. All right, and there was also this payment obligation that's right here inside. Okay, that is your promise to pay. Now, after closing, that note went from here, okay, down to here, county recorder's office, Volusia County Recorder's Office, where it was indexed, filed, and recorded. Okay, after which it was sent back to the originator, the lender in this case, and now we have a properly secured loan. All right, the mortgage attaches itself to the obligation, which is evidenced by the tangible promissory note. Now, what happens, though, is that when it comes back, all right, many times it's scanned directly into what they call their digital system. They've got all different names to it. Anyways, it's scanned in, all right, and it's stamped with a as of yet unnamed payee, paid to the order of empty space, without recourse. Now, it's very important. Without recourse means without liability. So once they give it away, you can't come back to the party that put without recourse and hold them liable for anything. You know, if that note was worth $100 and they sold it you for $100, and you find out it's only worth $50, you can't go back to them because it says without recourse. If you want to have fun sometime, take a check, and when you go down to the bank to go cash it, under your name, write without recourse. And you look at the number of people that are going to be running around like little mice in circles wondering what to do with your check. Because if that check bounces, the bank is liable, you're not liable. So just want to throw that out there. All right, so let's continue. Let's look at this. So we have the originator, and they scanned in the note. Why? All right, well, we've gone from electronically now, we are going to make a copy. We're going to scan in the mortgage. We're going to have a copy. All right. Now, when they make that copy, all right, this payment obligation, all right, right here, that is ripped out of the note. That is your promise to pay. That is a right to collect future payments for the next 30 years, 40 years, 15 years, whatever it is. That is what gives value to that note. But now when it is stripped out, okay, it is this obligation that is sold. Right? So it goes from the originator to the sponsor. The sponsor says, hey, I'm going to sell that obligation to the depositor. Right? So now the depositor then says, hey, I'm going to sell that obligation to the trustee. This is all done electronically. Prior to 1997, all right, before the inception of mortgage electronic registration systems, this was done manually. And it took anywhere between 120 and 180 days to go from all of these parties. Party A to Party B, Party B to Party C, Party D to Party E. So when you look at what is done today, and I'll show you a chart later of what it's supposed to look like, but this is what actually happens in many cases. So this obligation is sold, and many times the note, we don't know where it goes. It goes in a box someplace, all right? It just gets put up on the shelf, all right? It doesn't have the sponsor's name, doesn't have the depositor's name, doesn't have the trustee's name, doesn't have the trust name, all right? But this obligation, which is evidenced in these little purple arrows, okay? This obligation is the purple arrow, all right? When I talked about the following of the intangible obligation, that is what is tracked by MERS, Mortgage Electronic Registration Systems. Okay? It says after the tangible obligation is registered on MERS, any interest in the intangible payment obligation, they're tracked. Right? So when we looked at that MERS milestone report, all it did is track the servicing rights. It tracked this obligation. All right? Now, years later, all right, there is an assignment. Now, there is no assignment prior to a default. Nothing's transferred. Oh, wait a minute, you sold this. You sold this to this guy. You sold this to this guy, but yet nothing's in public record. And if you do a QWR or any other ERIR letter to specific parties and you get a copy of a note back, many times when you get a copy of the note back, it's signed, it says this is a certified true and correct copy, there are no endorsements on the note. All right? But yet, upon default years later, there's assignments that purport to take place and in public record. But we have a closing date here. All right, the closing date in this one, 1/26/06. Yet the assignments are done, 2014, 2015. So this is something to look at. Again, what is supposed to happen and what actually happens, two different things. This is what happens many times today. We've got a few other charts we're going to go over when we come back. So we need to be aware. The claims that are made, all right, that they purport to have taken place, right, where it says from the originator, boom, to the trust. Well, wait a minute. This is supposed to be a RMIC, and this is an RMBS, a residential mortgage-backed security. So how do we go from 06, okay, closing date, January 26th of 06, all right, to, or actually, That's the wrong closing date. But, you know, in 2014, they purport to do an assignment. Well, none of these parties are named. There's nothing in public record up here. So when we come back, we're going to keep on going. I hope you've enjoyed this so far. So we're going to take a 15-minute break, and we'll come back in 15 minutes and carry it. And I hope everyone is learning a lot. And I know I'm giving you a lot of information. So just keep on going. Get a 15-minute break, cup of joe, cup of water, and we'll be right back. Thank you. Okay, everyone. This is Joe Esquivel, and I'm back. So I'd like to continue. We were talking about on the infographic that we've created. And again, when we do the chain of title analysis, if we can do an infographic, I've got like 35 different types of infographics. We will do one. The only time that we are unable to do an infographic is, for instance, if you're with a static trust or in a private placement LLC. Again, I mean, I've got hundreds of hours for these infographics that went into it to create these. So occasionally I am unable to do an infographic, and if someone would like me to take the time and do an infographic, that would be hours and hours and hours, and the cost would be a couple $1,000s for one. But right now we've got about 35 different infographics that we do use. So anyways, one of the things that we were talking about for declaratory judgment was determining the status quo of parties, because we have a third party with a color of title claim to the property. All right, and that was done through an assignment, whether it be an assignment of mortgage, an assignment of deed of trust. Again, we have someone that is making a color of title claim. So let's take a look at this, because what we're talking about is MERS. Now this is, I have many different manuals, lots of manuals. I have Freddie Mac, Fannie Mae, Ginnie Mae. I've got MERS. I've got lots of different manuals. And this particular, I've taken out specific pages. There's actually 281 pages. Now, when we go through this procedures manual, I've read it. Here's one of the things that's interesting to note. This says on page 63, transfer beneficial rights to members, investors, under overview. Although MERS tracks changes in ownership of the beneficial rights for loans registered on the MERS system, MERS cannot transfer beneficial rights to the debt. The debt can only be transferred by properly endorsing the promissory note to a transferee. Again, MERS cannot transfer the beneficial rights to the debt. So if they cannot transfer the rights to the debt, then what are they transferring? They're just transferring a piece of paper, personal property, not real property. Let's go to the MERS terms and conditions. This is in their kit that goes to all of the parties that are members of MERS. All right? Paragraph 2. It says, solely as a nominee in an administrative capacity for the beneficial owner or owners thereof from time to time, MERS shall have no rights whatsoever to any payments made on an account of such mortgage loans to any servicing rights related to such mortgage loans or to any mortgage properties securing such mortgage loans. MERS agrees not to assert any rights. So not only does it say MERS shall have no rights to collect any payments, MERS agrees not to assert any rights. Let's jump down to paragraph 6. MERS and the member agree that MERS is not a vehicle for creating or transferring beneficial interests in mortgage loans. Okay, so while they purport to transfer rights to the beneficial interest, which is secured by the security instrument being either a mortgage or a deed of trust, it's actually personal property collateral as an alternate means of collection. The rights to the note do not extend to the mortgage or to the deed of trust. But yet they tell you, well, Joe, the mortgage follows the note. Always. No, it doesn't. It doesn't always follow the note. The mortgage, all right, or the security instrument follows a properly secured instrument. A properly secured. And that's just common law, but yet it's cited again and again. Carpenter versus Logan, 1872. But anyone that has been paying attention today would notice that earlier on the screen when I pulled up the Negotiables Instrument Act, that wasn't done until 1881. So we have people that are citing a clause, Carpenter v. Logan, all right, 1872, and yet that was cited under common law. That wasn't cited under statute. Statute didn't come about till 1881, the Negotiables Instrument Act, and then the Uniform Commercial Code 1961, and then whatever your state's equivalence to that Uniform Commercial Code being is today. Because all of these 50 states, with the exception of New York, which still uses the 1961 codified version of the Uniform Commercial Code, have all codified a newer version of what they use for their equivalence to the Uniform Commercial Code. So when they say we're transferring beneficial interest together with the note, read that 3 or 4 point font where it says many times, in about 50% of the assignments I see out there, together with the note. Wait a minute, how are you transferring the note? The note's transferred through a negotiation, transfer, and delivery. And how did you transfer beneficial interest in here? All you're transferring is a piece of paper. There were no rights that have been incurred by MERS. Paragraph 6 of this document on the screen says, the MERS system is not a vehicle for creating or transferring beneficial interest in mortgage loans. This is one of the things in our investigation that we look at. You need to identify, right, what has happened. Who has been damaged? How have you been damaged? Well, one of the things that you need to understand is that what is the capacity of these parties that are coming forth with these claims? Right? When I say they've slandered your title, all right? When you ask yourself, well, Joe, what exactly is it that they're saying? What exactly is it that they've slandered? Okay, well, there's 5 elements for slander of title. All right, so if we look at, okay, I'm going to give you the full version and then we're going to break it apart. Okay, because you need to understand how have you been damaged. And again, I'm speaking to parties that are in a presumption of deficiency. All right, I'm not talking about anyone that is current. I'm talking about when there is a presumption of a deficiency. That is what I'm talking about for slander of title. When someone has made a claim, all right, of a superior lien to your property. So, slander of title is a claim involving real estate in which one entity falsely claims to own another entity's property. It can also be casting aspersion on someone else's property, business, or goods. It can be defined as a false and malicious statement, oral or written, made in disparagement of a person's title to real or personal property, or some right of his, causing him special damage. Okay. The essential elements of a slander of title cause of action are the uttering and publication of the slanderous words by the defendant. That's one. The falsity of the words, malice and special damages, all right, those are the elements, all right? Those are the 5 elements. So when you look at the uttering of the publication, the slanderous words, the falsity, the malice, and special damages, right? This is what we need to prove. In order to establish the elements of slander of title, the plaintiff must prove that the defendant has communicated to a third party a false statement disparaging title which has caused the plaintiff actual damage. Okay. Malice is presumed if the disparagement of title to real property is false, causes damage, and is not privileged. However, the presumption of malice can be overcome by showing of privilege. A showing of privilege rebutes the presumption of malice, and the plaintiff must then prove actual malice in order to recover on a slander of title action. Okay, so let's just, now then, I'm giving you the big picture. Let's break it down. So, one second. All right, so we've gone over what MERS says. So, to break it in a nutshell, generally one must prove the following to bring a legally sufficient claim of slander of title. 1, there was a communication to a third party. B, it was a false statement. C, it was derogatory to another's title. D, it was with malice. And E, it causes special damages. Okay. So, when we say that they've damaged you, all right, the damage is the act of recording that document, because when they recorded it, now they've slandered title. Because there was a communication, it was a false statement, it was derogatory, it was with malice, and it caused special damages. All right, and how did I show that? Well, okay, so then I have gone through and I've showed, all right, how they have slandered your title. Again, filing of the document, all right, did A, it was a communication to a third party. B, the statement that MERS could assign the note or notes is a false statement because 1, MERS never owned the note. 2, MERS cannot own a note. 3, MERS has stated in fact under its own agreement that it cannot. 4, it's stated in the MERS procedure manual. This is what the chain of title analysis does. This lays the foundation for figuring out the capacity of these parties that are making claims to your property. All right? The same thing is for if there is any fraud that we would find within the property. You know, one would go to the elements of fraud and then go through the documents, because one cannot make mere allegations. To make a mere allegation, all right, will get whatever you're stating thrown out. It must be done with specificity and particularity, all right? So the chain of title analysis lays the foundation, all right, for the arguments. And we're going to go over a few more in a little bit, but I'd like to walk you through right now as to what is the investigation, all right? Because the investigation, this is a critical part, all right? This is laying the foundation of anything going forward, whether it be administrative, whether it be judicial, all right? You need to lay a foundation. You need to find out what has been, has been done, what has not been done. Okay, 1. The investigation is done by a licensed private investigator. Okay? If you go to this website, you can see all of our information that is licensed from the Texas Department of Public Safety. All right, so we're going to look at this like you look at an onion. I've got different layers, so I've got to peel it back. I've got to look at layer 1. What are the elements of a mortgage and how are they governed? So in your particular situation, again, depending on the instruments, is what I would look at. So I'm going to look at the tangible promissory note. All right, what is it? This is what we have talked about earlier, all right? I'm going to look at your tangible security instrument. I'm going to look in public record. I'm going to look at your court record, all right? I'm going to identify all the parties that are named. I'm going to look at who was not named, okay? Well, look at the security instrument. All right, what is a security instrument? It is a writing in tangible form to memorialize the obligor's or debtor's pledging of an asset or property, is an alternate method to secure payment to a tangible obligation if, and in accordance with all applicable laws of jurisdiction, and it is governed by local laws of jurisdiction in which the real property resides. All right? That is what a security instrument is, a tangible security instrument. All right, let's look at the security interest, the pledging of the tangible alternate real property rights for payment. Okay? The security interest is an interest constituting a lien or claim which was created by a security agreement, being a mortgage or deed of trust, or by the operation of law, that if valid and enforceable, it provides the alternate means to fulfill value of an intangible financial obligation between the tangible obligee and the tangible obligor. Thus, if such security interest, being a mortgage or deed of trust, is no longer valid or enforceable in accordance to local laws of jurisdiction, then the tangible UCC-3 note is no longer secured by such security interest. All right, so what we're saying here is that, all right, this security interest, right, it's pledged, all right? It is pledged, all right, your rights for payments, all right? They say, okay, I promise to pay, all right? Now, in order to secure that promise to pay in accordance with law, the note must be sold, the security instrument must be assigned, and the debt must be sold along with the note. So we look at the tangible promissory note. We also look at the intangible E-note. All right, the intangible payment obligation. All right, again, we look at the security interest. Now, Your security interest, your promise to pay, that intangible payment obligation, when we talked about it being sold by an account debtor to an intangible obligee, that is legal. They can do that. And that falls under UCC Article 8, and that is referred to as an E-note. But they do not talk about servicing the E-note. All right? They talk about control of the E-note. All right. Now this security interest, all right, which is the intangible payment stream, all right, to the UCC Article 8 note, all right, that is the intangible obligation. So not to confuse you, there are multiple notes that the homeowner is not told about. There is an electronic version of the note, there's an electronic version of the mortgage. And it is these electronic versions that are bought and sold every day electronically. They would lead you to believe that the tangible documents have been bought and sold and secured into public record in accordance with law, but that does not happen. So while they sell an Article 8 electronic note, they try to use the assignment of mortgage or the assignment of deed of trust to say, well, this mortgage, assignment of mortgage is securing this note. No, that assignment of mortgage has been pledged to a tangible promissory note with an intangible payment stream. You cannot pledge, all right, that instrument more than once, but yet that is what is done all the time. All right, so one, we look at your documents. That's the first layer. Two, we go into land records. The land records are documents of transactions being claimed that have been recorded in the public record, thus giving constructive notice to the world. Layer three, okay, then I go into statutes and law. And again, when you look at all of the different law that we need to look at, it's very intense. We get into U.S. code, we get into federal law, we get into Uniform Commercial Code, then we get into state law, then we go to local laws of jurisdiction. So each time we're burrowing down deeper and deeper. Again, depending on your specific circumstances. What applies to John Doe in Florida may not apply in California. What applies in Pennsylvania may not apply in New Jersey. So whatever your specific situation, all right, we'll make a determination as to where we are going to go. This is one of the things that we look at. The first sale from party A to party B, along with the first assignment, with party A releasing its security interest in the security instrument, personal property, and then assigning the interest to party B and recording this transaction into public record. I look at that. Did that take place? Yes or no? It's not a legal opinion. It's not a legal conclusion. I have no legal opinion. These are facts. The second sale from party B to party C, along with an assignment, with party B releasing its security interest in this security instrument, and then assigning the interest to party C, and recording this transaction into public record, we look at that. Did that take place? Again, it's a fact. Was there a third sale from party C to party D, along with an assignment with party C releasing its security interest in the security instrument and assigning that interest to party D and recording this transaction into public record? Did that take place? All right. Was there a fourth sale from party D to party E, along with an assignment with party D releasing its security interest in the security instrument and assigning the interest to party E and recording this transaction public record? Now, it looks like I'm repeating myself, but if you follow the progression, all right, all of these transactions pertaining to the note, all right, and to the mortgage or deed of trust are to be done in parallel. All right, there was a sale of the note, sale of the debt, an assignment recorded in public record, releasing beneficial interest and assigning beneficial interest from party A to party B. All right, sell the note to party B to party C, sell the debt from party B to party C. I'll do an assignment from party B to party C. Party B releasing, assigning to party C. So depending on how many transactions were to take place, that is what we look at. All right. Layer 4 is where we do a comparison, where I'm going to compare all the documents and all of the records of both the tangible and the intangible to the statutory requirements of law pertaining to the sale of the entire mortgage loan instrument, consisting of the tangible promissory note, a tangible security instrument securing the indebtedness, and the intangible obligation, which is the promise to pay. This is what it looks like, people. Hundreds and thousands of papers. This is what, my desk, I've got piles of papers. All right, even though I receive a lot of papers electronically and I ask for everything electronically, all right, many times I have to print them out and look at them, all right, physically. Many times we are sent documents physically. These are governing documents pertaining to your specific instance. Depending on your situation, you may or may not have one. Pool and servicing agreements, 424B5 prospectus, free writing prospectus, trust agreements, circular supplements, selling guides, custodian manuals. So all of these documents are part of the investigation. So depending on your situation is what I will look at. Whatever we can pull up. So if we have to go to Security Exchange Commission, I go there. We look at the 8Ks, the 10Ks. Those are the yearly filings and the annual filings that are done with the Security Exchange Commission in order to do business. They need to put these filings into public record. Then I ask, what did happen? All right, so I've done a comparison. I've looked at all the documents. I've looked at all of the records. Then I ask, what did happen? Valid question. All right, so what did not happen or not take place according to the statutory requirements of law, as well as the governing documents that were required in order for true sales to take place? This is a valid question. What requirements were violated, or what statutes were violated in regards to keeping tax status as a REMIC? And were the timing requirements met? Because in order to be a REMIC, all right, under IRS Tax Code Title 26 860D, right, they agreed to follow certain mandated rules set by IRS. So either they're lying to IRS or they're lying to public record and they're lying to the courts as to what documents actually are fraudulent. What are legit, what isn't legit. Someone's not telling the truth. We need to hold feet to the fire. Okay, then we take all these conclusions and we put those findings into a concise package that consists of the chain of title analysis, your infographic. All right, here's another infographic. Now, in this infographic you can look at, I'm going to blow it up. You saw what did happen. And here, this shows what was to happen. The difference is this is what did happen. All right? This is what was to happen to the loan. All right? When we have the borrower, okay, in this case it's Jane Doe, and we have the Doe note and the Doe mortgage, all right? When you look at it, all right, we had the signing. After signing, it went to Orange County Recorder's Office, came back, all right, with now properly secured mortgage. Okay, well, they did the same over here the first time, and then it got sent back. These two are the same. All right, then the originator decided to sell the note and the tangible payment obligation to the sponsor seller. All right, so what did they do? Well, they did an assignment of public record where it was indexed, filed, and recorded, came back properly secured. All right, now the sponsored seller, all right, sold to the depositor the note, the payment obligation, was transferred by an endorsement negotiation, all right, pursuant to statutory requirements of law. At the same time they sold to the depositor from the sponsor, all right, they did an assignment recorded in the public record in a timely fashion, where it's indexed, filed, recorded, properly perfected. Now the depositor has it. Now the depositor has it, and the depositor says, I'm going to sell it to the trustee for the trust. Same time I do it, I'm going to do an assignment, all right, to the trust. All right? So again, this is what happens. So it's naming the trustee for the trust. So this is what is to happen. This is what actually happens. Night and day. We've got filed in public record, filed in a 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 public record. And all that was to be done by the closing date of the trust. Let's see, closing date of the trust was July 6/05. Closing date of the trust, 8/17. Well, they had to work really fast because they had a month and like 5 days to get it done. What actually happened was that they stripped the guts out and they sold this intangible payment obligation. All right? That's what they actually did. All right? They recorded the mortgage one time into public record, and that was up here in 05. All right? The problem was when they stripped this out, the mortgage was no longer secured to the tangible note. All right? We don't know what happened to the note. All right? There were no endorsements or anything, but they sold the right to collect future payments. All right? They later did 2 assignments. They purported to do an assignment. What they're attempting to do is a legal impossibility. Now, what we do on the charts is we reference the specific paragraphs within the chart. So the chart is referenced in the analysis is referenced in the chart. Now, rights are required by statutory requirements of law. So the enforcement, though, rights of enforcement are statutory also, but it is also based on how was the note negotiated. So this is something, again, people need to take a look at it. They're not, what you think happened isn't what actually happened. Okay, then we get to information on endorsements. We see, again, depending on the documents that you have, if we have your notes, we're able to go through that. Okay, we do a voluntary liens report as well. We do an affidavit of fact. Because the analysis, again, it's an analysis. The affidavit of fact is an affidavit which states, I, Joseph Esquivel, I looked at these documents. I looked at a note. On this note, I saw an endorsement. The endorsement was on a launch. Here's what the endorsement said from Billy Bob Thornton, President of Bank of America, to Willy Wonka of the Wonka Factory. All right, I saw a second endorsement. So depending on what I look at into public record, depending on the documents that I'm given that are filed in the complaint, that are evidence in the court record. So whatever documents I have will make a difference as to what that affidavit of fact says. So depending on what your documents state. Okay, so all of this being said lays a foundation for declaratory judgment. All right? The analysis is everything. I cannot stress to you enough. The analysis is everything. All right? Again, color of title is what their claims are. Without an analysis, right, you are not going to know, all right, what has happened to your property. We need to understand just because they make a claim that something is so does not make it so. So the investigation is essential for any action going forward, whether you be judicial, administrative, whatever. All right? In addition, once we have looked at your documents, one of the interesting things is that we've been looking at causes of action, because that is what the analysis brings out. What is a cause of action? Recently, we've added a cause of action being breach of contract. Now, depending on your specific situation, right, we've been able to go in there and look at the documents and see, have they breached a contract? All right? What did that contract say? So one of the things we've been looking at was breach of contract. What was breached? Well, again, depending on your specific instance, in this specific instance, when I go to Covenant 23, it says reconveyance. Upon payment of all sums secured by this security instrument, lender shall request trustee to reconvey the property and shall surrender this security instrument and all notes evidencing debt secured by this instrument to trustee. Trustee shall reconvey the property without warranty to the person or persons legally entitled to it. Well, let's see. When I looked at your documents, I did not see a deed of release of deed of trust. I did not see a reconveyance of deed of trust, a reconveyance of the property. So they've breached a contract that I signed in which they said upon payment of all sums. Well, let's see. You sold my loan from party A to party B. You agreed to that. But yet, I see no release. So this is how one of the causes of action that we're able to look at and see, okay, did they breach a contract? So I'm going to bring up a mortgage one. Again, that's for deed of trust. That was for Nevada. So let's look at another one. Okay, you may not be able to read it, but it says released. Again, Covenant 23. It says, upon payment of all sums secured by this security instrument, lender shall release this security instrument. Everybody, you're reading the same thing that I am. So when it says upon payment of all sums secured by this security instrument, this was a condition for the contract that I signed. They have breached the contract because they did not do what the contract stated they were to do. It is unenforceable if you do not follow what the contract says. If I say I will paint your house green and I paint your house orange, and we have a contract that I said I would paint your house green, but I didn't, I painted it orange, there is a breach of contract. So in here, all right, through a consciousness of innocence, I signed this document, and it said on Covenant 23, release upon payment of all sums secured by this security instrument, lender shall release this security instrument. So I signed this, all right, with this intention that upon payment, they would release the security instrument. They got paid. These sums secured by the security instrument were paid to the lender. They had an obligation to release their personal property interest, which is an alternate means of collection. All right, and then I would sign a new security instrument with the new owner. That never happened. So they received money, payment of all sums. It didn't say buy this to here. It says upon payment of all sums secured by this. It's very explicit. So I have been damaged, all right? They were to do specific requirements of this contract as I was to do specific requirements. If they didn't fill their end, all right, we have an unenforceable contract. And this is very, very important. Because the mortgage is an alternate means of collection. So if they got paid for it, it's no longer secured. It says shall release. It doesn't say may. It says shall. That's what that word means. You need to do this. So this is one of the arguments, again, depending on your state, depending on your lender, would depend on the specific instance. One of the things that you can do is just review again and again and again what we're talking about. I'm going to go briefly through a sample. Again, we've covered quite a bit. One of the things that you will do when you receive this is we have gone into detail at great lengths, probably more so than any homeowner, real estate, even attorneys would do. We've gone as high as an academia level and yet brought it down so the homeowner can read it and understand what is being said. But there is no mincing of the words, right? The first 8 pages that we talk about are what we have talked about in this webinar, right? To educate you as to the proper definitions, right? So when we go through, we talk about personal property, what really got securitized, what should have happened. Again, you need to read this again and get an understanding. So when someone asks you, well, what did happen? What did not happen? We talked about 15 U.S.C. 7003, which clearly excludes instruments governed by the Uniform Commercial Code, Article 3, 8, and 9, or the state equivalent. So the intangible claim cannot be negotiated electronically. Everything needs to be in writing, right? We talk about how it happened, what happened. Again, while it's clear and concise, it's written so you can understand it. We talk about conveyance of an e-note, right? An electronic note, which is created electronically, recorded electronically, stored electronically, right? It's electronic. It's not tangible. You can't touch it.
You can't touch this. Can't touch this. You can't touch this. You can't touch this. My music hits me so hard, makes me say, oh my Lord, thank you for blessing me. What am I to rhyme and to hype me? It feels good when you know you're down. A super dope homeboy from the Oak Town, and I'm known as such, and this is a beat.
So we get into great detail with that. So the first 8 pages you need to read again and again and again and understand, right? Because this all applies to everyone. So whatever your situation is, again, I referenced the Uniform Commercial Code up here, UCC Article 9. If I'm in Florida, I'm going to recognize, Florida's equivalent to Uniform Commercial Code for Article 9. If you're in California, I'm going to refer to California Commercial Code. If I'm in New York, I'm going to go to UCC 1961 version. If I'm in Texas, I'm going to go to Texas Business and Property, Business and Commerce Code. So whatever your situation is, we are going to apply that to the investigation. So these first 8 pages talk in generality. All right, so do not get confused where it says UCC 3. All right, well, what is your state's equivalent to UCC 3? Florida falls under 673. Okay. Then we get into the transaction history. All right, so depending, again, the documents we have, the information that we are given, it's put so you can see it in plain black and white. In this instance, it's in an RMBS. All right, so it tells the classes where we found it. Here's a picture of it. All right, then we talk about the infographics. And what is the infographic? We have an example, all right here. Again, depending on yours, if you have Freddie or Fannie, again, yours will look different. Okay, here's one with Freddie Mac, all right, with no MERS. It's just went from the borrower to the originator to Freddie Mac. Again, many times you can have 2 or 3 parties just as if you had it in RMBS, from the borrower, lender, originator, sponsor. Each situation is different. In this specific instance, all right, we just had a borrower, the originator, which was the lender. All right, John Doe signed the note. The mortgage went to the recorder's office. It came back with properly secured. It was scanned into their system. It was stamped with an as of yet unnamed payee. All right. However, what had happened was they had ripped out this intangible payment obligation, and they had sold the intangible payment obligation to Freddie Mac. And then Freddie Mac had created a second intangible payment obligation and took that obligation and they put it into these Freddie Mac certificates for this Freddie Mac Trust 2005-6. And then they sold those certificates to the investors. But the note never made it down to the Freddie Mac Trust. There's nothing filed in public record. All right, showing it went to Freddie Mac. Now, interesting, all right, an assignment listing Freddie Mac as an assignee is created in recordable form, but not actually recorded. Now, this is described in the third-party custodian Freddie Mac form, and it's 1035A revision 8/0 section 3, all right? This is the document where I've got this verbiage, okay? So I'm not making this up. See this verbiage right there, right? This is the manual, and I have it, and I've read it, and this is what it states. Quote, a determination that the assignment, all right, of the security instrument from seller, servicer to Freddie Mac is duly completed and executed and in form suitable for recording, but not recorded. And that all intervening assignments have been duly completed, executed, and recorded. Therefore, while the security instrument is purported to have been assigned to Freddie Mac, such assignment was not assigned of record. If the assignment had been filed in record, then Freddie Mac could have been a party identified to allow for lien perfection. As the security instrument cannot be separated from the note, any negotiation of the note would require an assignment of the security instrument from the original lender to the subsequent owner of the note. Therefore, any sale or transfer of ownership of the note without effectively assigning the security instrument would render the sale as selling an unsecured obligation. In other words, if you just sell a partial piece of the note, you didn't sell the whole note. It's like selling credit card debt or student loans. there's nothing to back them up. It's unsecured debt. We then get into the mortgage fraud investigation and analysis, and I list the documents that I have looked at. All right, so you can see what documents I looked at. If I missed a document, you tell me you missed it, but I put in here what documents I looked at. All right, then we get into what we had found. What did I find? All right, so I'd give you the date that I researched, the loan number, and where I identified it. All right, so depending on your specific circumstances, it changes. All right, so then we go through whatever your situation specific is. All right, whatever statutes, the arguments, whether it's a RMBS or whether it's a GSE, every investigation is different. They all look similar. Your circumstances are all different. So I go through and, like I said, we just had one yesterday. They had 5 assignments, and they were all private. So you may or may not have a substitution trustee. If you're in California, you will. If you're in Florida, you won't. But this is the basis for laying the foundation. I can't stress enough, again, whatever, on this one, I'm talking about UCC 7501. If I was in California, it'd be California Commercial Code 7501. Again, it's just your particular state, all right, would make a determination as to what statutes we use. So again, you may not have all of the covenants. If you have Ginnie Mae, there's certain covenants you have, certain covenants you don't have. Not everybody has MERS, so depending on the circumstance, depending on the documents that I have, would determine what we find. But this lays the foundation of us going forth as to determine, all right, the status quo of the parties, the legal capacity, all right, the damages that have been done or have not been done. Everything is all about the analysis. Without an analysis, you're just shooting blanks. You have no idea. You're grasping at straws.